All right, I got a request from a gentleman who is an audio video learner, and he asked if I wouldn't mind sharing my screen while I'm doing these videos, and asking you shall receive, right? A little bit of equity. I can appreciate that. I'm also an audio video learner as well. That's why in part I do these videos, because believe it or not, I go back and I review this material while I'm traveling, or before I'm going to bed. I'll put it on play, and I will sit there and I will listen to it. Scientifically, they say that a man or a woman retains the most knowledge about 30 to 40 minutes before they go to sleep, and about the first 30 to 40 minutes in the morning when they wake up. Whether or not that's true, I don't know. It's what I've read, and so that's why I make these videos, is because I go back and I listen to them, and I'm hoping that they're helping all of you guys. There are people who have arguments, whether they're valid or not, is yet to be determined. Stating that some of the stuff I talk about only applies to federal citizens. Well, that's all fine and dandy to have that belief. But if you understand the true history of what happened in America, Congress never had the authority to ratify the 14th Amendment, period, because Congress was no longer seated as the de jure republic form of government, not a Republican form of government, but the republic form of government. It's a little Jesuitical tricks that they do. They change words just minutely, ever so slightly, to such a degree that many people overlook it. There is law to grammar, just like there's a law to mathematics, okay? And if you don't follow the law of grammar, it's easy to get lost in translation. And then what we draw is inferences based upon what we believe. But one of the things the court says is you're not allowed to draw an inference from an inference, because it quickly becomes distorted. An inference, again, would be a belief of something, or the way that one believes that it could be or should be. And again, belief is the lack of knowledge. So, due in part to the gentleman who asked me to share my screen, I do my live feeds from my phone, and I obviously am utilizing a laptop computer for reviewing the information as I go along. And so today, you won't be able to see my lips for those of you that follow me that are hearing impaired. I know I've got quite a few followers that request to be able to see my lips as I speak. I would encourage you to use the CC on the device so you can read along as we go, and then you also have the words in front of you as well. So maybe this is the best of both worlds. My ugly mug is not on the screen, and you guys can see where I'm drawing this information from. Again, I always encourage people to do their own research. Don't believe just because I think I've found something that it is factual. There are times, many of times, in fact, that cases have been presented to me. They look really good. They resonate with my heart, my mind, my body, my spirit, my soul. And I'm thinking, yeah, this is it. This makes sense. And only to go back and read the case and find out that it doesn't say anything near what it purports to say. I've recently learned about slip opinions, and some other things that you have to go into the law library to actually look. So maybe, just maybe, in some of these cases that don't actually report what the conclusion was accurately, maybe they're on slip opinions. Perhaps they're unpublished quotes from the judges pertaining to it. In any instance, we're going to get started here. Hatfield versus London, 98 Washington 516, based upon the fundamental grounds that the sovereign state has the plenary control of the streets and highways, and exercising of its police power, see police power infra, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinctions between the ordinary right of the citizens to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right. The latter is an extraordinary use. As to the former, the legislative power is confined to regulations. As to the latter, it is plenary and extends even to absolute prohibition. Since the use of the streets by common courier is in the prosecution of its business as such is not a right but a mere license of privilege. Why? Because government was instituted amongst men to monitor commerce, to make sure that the commercial venue, the commercial jurisdiction was not encroaching upon the rights of the people, ladies and gentlemen. That was a good reason for having government instituted amongst men, to make sure that business dealings and contracts were honored, followed, that they weren't written vague and ambiguously, that they didn't create a disadvantage on one party and benefit another. That's what government was used for. Used in the usual way versus extraordinary. Absolutely, Keith. Let's carry on here. Somebody else was asking me to explain things in my view, so that's why I'm kind of doing a little bit of that. Haffer versus Milo, 502 U.S. 21, 1991. To disregard constitutional law and to violate the same creates a sure liability upon the one involved. That means there is no qualified 11th Amendment immunity, ladies and gentlemen. State officers may be held personally liable for damages based upon actions taken in their official capacity. Haggins versus Levine, 415 U.S. 533. The law requires proof jurisdiction to appear on the record of the administrative agency at all administrative proceedings. And when we're talking about jurisdiction, which venue are we in, Your Honor? Is this a private administrative tribunal, Article 1, Section 8, or is this an Article 3, Subsection 2, qualified venue, an actual court of record? Which is it? Hale versus Hinkle, 201 U.S. 4374-75, 1906. We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to investigation, so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life, liberty, and property. His rights are such as the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its character. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislator to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not, in exercise of its sovereignty, inquire how those franchises had been employed and whether they had been abused, and demand the production of corporate books and corporate and papers for that purpose. All right. Remember when I'm telling you guys, the police station, the police department has its own private corporate charter. All right. And that corporate charter states that it must be within the confines, or it's bound by, rather, I should say, the Constitution for the state and the Constitution for the United States of America. So if their private policies are overreaching the delegated authorities by we the people in the Constitution set forth to the government has a responsibility to act and put these corporations, one, out of commission, or two, bring sanctions against them, or both, right? And it also has the obligation and the duty to make sure that a trespass will not be without a remedy, especially when it is causing harm to the people for which the constitutions were put in place to protect. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and person or thing to be seized. The Constitution of this amendment was exhaustively considered in the case of Boyd versus the United States 116 U.S. 616, which was an information in rem against, in rem means against things, okay? In rem means things, all right? And rights are things, all right? There's tangible and intangible property, okay? Against certain cases of plate glass alleged to have been imported in fraud of the Revenue Acts. On the trial, it became important to show the quantity of the value of the glass contained in the number of cases previously imported. And the district judge, under subsection 5 of the Act of June 22, 1874, directed a notice to be given to the claimants requiring them to produce the invoice of these cases under penalty that the allegations respecting their contents should be taken as confessed. We held P. 116 U.S. 622 that a compulsory production of a man's private papers to establish a criminal charge against him or to forfeit his property is within the scope of the Fourth Amendment to the Constitution in all cases in which a search and seizure would be, and that the order in question was an unreasonable search and seizure within that amendment. The history of this provision of the Constitution and its connection with the former practice of general warrants or writs or writs of assistance was given at great length, and the conclusion reached that the compulsory extortion of a man's own testimony of his private paper to connect him with a crime of a forfeiture of his goods is illegal. P. 116 U.S. 634. A corporation is, after all, but an association of individuals under an assumed name and with a distinct legal entity. In organizing itself as a collective body, it waives no constitutional immunities appropriate to such body. Its property cannot be taken without compensation. It can only be proceeded against by due process of law and is protected under the 14th Amendment. Okay, remember the 14th Amendment deals with slaves and deals with corporations, all right? It doesn't deal with free men, okay? Against unlawful discrimination, Gulf and Sea Railroad Company versus Ellis, 165 U.S. 150, 165 U.S. 154, and cases cited, corporations are a necessary feature of modern business activities, and their aggregated capital has become the source of nearly all great enterprises. Mr. Justice Harlan, concurring, in my opinion, a corporation, an artificial being, invisible, intangible, and existing only in contemplation of law, cannot claim immunity given by the 4th Amendment, for it is not a part of the people within the meaning of that amendment, nor is it embraced by the word person in the amendment. If a contrary view obtains the power of the government by its representatives to look into the books, records, and papers of a corporation of its own creation to ascertain whether that corporation has obeyed or is defying the law, will be greatly curtailed, if not destroyed. If a corporation, when its affairs are under examination by a grand jury, page 201 U.S. 79, proceedings in its work under the orders of the court can plead the immunity given by the Fourth Amendment against unreasonable searches and seizures. May it not equally rely upon the amendment to protect it even against a statute authorizing or directing the examination by the agents of the government creating it, of its papers, documents, and records, unless they specify the particular papers, documents, and records to be examined. Since it was the Supreme Court, of the land, until another Supreme Court case says it is not. Has another Supreme Court case overturned Hale versus Hinkle? The answer is no. As a matter of fact, since 1905, the Supreme Court has cited Hale versus Hinkle a total of 144 times. A fact more astounding is that since 1905, Hale versus Hinkle has been cited by all of the federal and state appellate court systems a total of over 1,600 times. None of the various issues of this case have ever been overruled. Hendrick versus Maryland SC Reporters RD 610-625, 1914. A citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident, does not have the common law right to travel of a citizen of one of the several states. So herein laying out a distinction, and again, I would implore you to go check out this case. Make sure that this verbiage is in there. Go look for the slip opinions. You may end up having to go into the law library to actually research this case to get all the evidence, because a lot of this stuff is unpublished, okay? But if you listen to what it's saying here, there's a clear distinction between residents of the United States, okay, and citizens of one of the several states. Now, citizens of the several states, from the literature that I'm reading, is not the same as the citizens of the Union of States, okay? But just looking at this, they're already laying out a clear distinction, all right? If you claim to be a United States citizen, let me tell you something. You do not have a right to travel, okay? You have privileges, you have immunities they give you, and they can be taken away at any fucking time, all right? But if you're a member of one of the Union of States, protected and domiciled in Article 1, Section 10, right, of the United States Constitution, and it's also found in every state constitution as well. The same verbiage, almost verbatim, is found in every state constitution. And you're domiciled there, right? That's where the man is protected, okay? The sovereign man is protected in Article 1, Section 10 and Article 1, Section 9. Hillhouse versus the United States 152F, 163, 164, Second Circuit, 1907. A citizen has the right to travel upon the public highways and transport his property thereon. State versus Johnson, 243P, 1073. Cummins versus Holmes, 155P, 171. Packard versus Banton, 44S period, CT period, 256. And Hatfield versus London, 98. Washington, 516. Willis versus Buck, 263P, I, 982. Holland versus Shackleford, 137 S period E period 2D 298 304 220 Georgia 104, and Stavala versus Palmer 73 A period 2D 831 838 136 Connecticut 670. There can be no question of the right of automobile owners to occupy and use the public streets of cities or highways in the rural districts. Lieberich versus Crandell, 126 N period W period 69 110 Minnesota 454 456. The word automobile connotes a pleasure vehicle designed for the transportation of persons on the highways. Home versus State, 404 P2D 740 1965, and a person is not to be deprived of life, liberty, or make off. Hoke versus Henderson, 15 NC 1525 AM DEC 677, that a statute which would deprive a citizen of the rights of persons or property without a regular trial according to the course and usage of common law would not be the law of the land. Hoke versus Henderson, 15 N period C period 1 NC 1833, verified Justia. Supreme Court of Northern Carolina, as one of the original 13 states, this case would hold precedent over newer states. They must have case law, and again, it's case precedent because the judiciary was never granted the authority by the people or the Constitution to create fucking law to reference for their courts to function as newly formed states. In absolute governments, whether hereditary or representative, the division of powers of government is unimportant because that body is in which resides the superior authority can at will make it supreme and absorb all of the other departments. It does not follow, therefore, that because of the British Parliament, whose supremacy is acknowledged, decides questions of private right and puts that decision as it does its other determinations into the form of a statute, that whatever it does is legislative in its nature. It can adjudicate, and often does substantially adjudicate, when it professes to enact new laws. That faculty is expressly denied to our legislator, as much as legislation is denied to our judiciary whenever an act of assembly therefore is a decision of Title 13 between individuals, or decisions of titles between individuals or classes of individuals, although it may in terms purport to be the introduction of a new rule of title. It is essentially a judgment against the old claim of right, which is not a legislative but a judicial function. It may not be easy to distinguish those powers and to define each, so that an act shall be seen at once to be referable to the one or the other. But I think that where a right of property is acknowledged to have been in one person at one time, and is held to cease in him and to exit in another, whatever may be the origin of the new right in the latter, the destruction of the old one in the former is by sentence. Those terms, law of the land, do not mean merely an act of the General Assembly. If they did, every restriction upon the legislative authority would be at once abrogated. For what more can the citizen suffer than to be taken, imprisoned, deceased of his freehold, liberties, and privileges, be outlawed, exiled, and destroyed, and to be deprived of his property, his liberty, and his life, without crime? Yet all this he may suffer. If an act of assembly simply denouncing those penalties on particular persons or a particular class of persons be in itself a law of the land within the sense of the Constitution, for what is in that sense the law of the land must be duly observed by all and upheld and enforced by the courts in reference to the infliction of punishment and diverting of the rights of the property. It has been repeatedly held in the state, and it is believed in every other of the Union. See, they're talking about the Union estates now. That there are limitations upon the legislative power, notwithstanding those words, and that the clause itself means that such legislative acts as profess in themselves directly to punish persons or to deprive the citizen of his property without trial before a judicial tribunals, and a decision upon the matter of right as determined by the laws under which it vested according to the course, mode, and usage of the common law as derived from our forefathers, are not effectually law of the land for those purposes. Horst versus Moses, 1872, 48 Alabama, 129 at 142. To confer a title of nobility is to nominate to order of persons to whom privileges are granted at the expense of the rest of the people. It is not necessarily hereditary, and the objection to arise more from the privilege supposed to be attached than to the otherwise empty title or order. Horst versus Moses, 1872, 48, Alabama, 129 at 142, 46, Corpus Juris 598, Nobility, Note 4, 1874, Bouvier's Law Dictionary, Nobility. These component terms, privilege, honor, and emolument, are collectively in the term title of nobility. House versus Kramer, 112, N period, W period 3, 134, Iowa, 374. Fransworth versus Tampa Electric Co., 57 SO period, 233, 237, 62 F, Florida, 166. The automobile may be used with safety to others, to other users of the highway, and in its proper use upon the highways, there is an equal right with the user of other vehicles properly upon the highways. The law recognizes such right of use upon general principles. Indiana Springs Co. versus Brown, 165, Indiana, 465, 468. U.S. Supreme Court says no license necessary to drive automobile on public highways, streets. No license is necessary. Copy and share freely. YHVH, Yahweh, name. 22, a highway is a public way open and free to anyone who has occasion to pass along it on foot or with any kind of vehicle. Schlesinger versus City of Atlanta, 129 S period E period 861, 867, 161, Georgia 148, 159. International Motor Transit Co. versus Seattle, 251 P period 120. The term motor vehicle is different and broader than the word automobile. Jackson versus Mongolia, 20 HOW period 296, 315, 342 US 1852. Next to revenue itself, the late extension of jurisdiction of the Admiralty are our greatest grievances. The American courts of Admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England dangerous innovation if the trial of any matter on land was given to Admiralty. Everyone knows how strenuously the Admiralty jurisdiction was resisted in England by the common law lawyer headed by Coke. The contest lasted for 2 centuries. The Admiralty civilians contended that the statutes of Richard II and 2H4 did not curtail the ancient jurisdiction of the Admiralty over torts and injuries upon the high seas and in ports within the ebb and flow of the tide, which was shown by an exposition of the ancient cases, as was opposed by the common law courts. But they continued to contest until they acquired a concurrent jurisdiction over all maritime causes except prize. The Vice Admiralty courts in this country, under the colonial government, exercised jurisdiction over all maritime contracts and over torts and injuries, as well in ports as upon the high seas, and this was the jurisdiction conferred on our courts by the Constitution. But it was not until a late period that the jurisdiction of the Admiralty in England was settled by the Statute of 3 and 4 Victoria, C-67, passed in 1840. This is entitled An Act to Improve the Practice and Extend the Jurisdiction of the High Court of Admiralty in England, and it is gratifying to the bar and bench of this country to know that the above statute has placed the English Admiralty substantially on the same footing that it is maintained in this country. To this remark, it is believed there are but 2 or 3 exceptions. Insurance, ransom, and surveys are believed to constitute the only exceptions. The flow of the tide, as before remarked, is used to designate the navigableness of their rivers. Whether an insurance is within the Admiralty has not been considered by this court. It is singular that while the English Admiralty, by its extensions, has been placed substantially upon the same basis as our own, ours should be denounced as having a dangerous tendency upon our interest and institutions, and a desire expressed to abandon the enlightened rules of the civil law and follow the misconstrued statutes of Richard II, page 61, U.S. 307. Joyce versus U.S. 474 2D 215. There is no discretion to ignore lack of jurisdiction. A judgment rendered by a court without personal jurisdiction over the defendant is void. It is a nullity. Juilliard versus Greenman, 110 U.S. 421. There is no such thing as inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. Kawananuka, that's one of those pineapple chuckers, I'm sure of it. Kawananaka versus Polly Blank, 205 U.S. 349, 1907. A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical grounds that there can be no legal right as against the authority that make the makes the law on which the right depends. And as the doctrine is not confined to full sovereign powers, it territories of the United States, which in actual administration originate and change the law of contract and property. The territory of the United States differs from the District of Columbia in that the form is itself the fountain from which rights ordinarily flow, although Congress while in the latter, the body of private rights is created and controlled by Congress and not by a legislator of the district. Verified Justitia. Kent versus Duels. See Vessel. Freedom of Movement. 41 Iowa. L period, REV period 6, 13 through 14. The validity of restriction on the freedom of movement of particular individuals, both substantively and procedurally, is precisely the sort of matter that is the peculiar domain of the courts. Comment 61, Yale L period J period at page 187. A person detained for an investigatory stop can be questioned but is not obliged to answer. Answers may not be compelled, and refusal to answer furnishes no basis for an arrest. Justice White, Hybel. Automobiles have the right to use the highways of the state on an equal footing with other vehicles. The right to travel is part of the liberty of which citizens cannot deprived without due process of law under the Fifth Amendment. This right was emerging as early as the Magna Carta. Kent versus Duels, 357 U.S. 116, 1958. Kittles versus Rocky Mountain Recovery, 1P period 3D 1222, Wyoming 2000. In any event, it is the practice of this court to treat all petitions for extraordinary relief as petitions for writs of review, no matter how that petition might be captioned at filing. Okay, so what he's saying is equity disregards the form and looks at the substance and intent. All right, that's the maximum that I would put with this right here. All right. Upon initial consideration of that notice of appeal, the court had two options. One, dismiss the appeal, explaining that the petition for writ of review was the proper vehicle for bringing the district court's order before this court. Or two, treat the notice of appeal as a petition for writ of review. In this particular case, the court opted to treat the notice of appeal as a petition for a writ of review. We caution practitioner that in many, if not most instances, this court will dismiss appeals filed under these circumstances. Lancaster Co. versus Trimble. A county is a person in legal sense. Lancaster Co. versus Trimble, 34, Nebraska, 752-52, N period, W period, 711. But a sovereign is not. In regards to Fox, 52, New York, 535, 11 AM period, REP period, 751, US v. Versus Fox, 94, US, 315, 24, L period, ED period, 192, Black's Law Dictionary, 4th edition, page 1300. Lansing versus Smith, 4 Wind period D, New York, 1829, 21 AM period, DC period 89. The people of this state, as the successor of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Through the medium of their legislator, they may exercise all the powers which, previously to the revolution, could have been exercised either by the king alone or by him in conjunction with his parliament, subject only to those restrictions which have been imposed by the Constitution of this state or of the U.S. Lansing versus Smith, 21D, 89, 4 Wendell, 9, 1829. New York Lansing versus Smith, 4 Wind, 9, New York, 1829, 21 Am DEC, 8910C, Constitutional Law Section 298, 18C EM period DOM period SEC period 3 228. When we come back, we'll get into, we'll just go through this one. Lantana versus Hopper, 102 F period 2D, 188 Chicago versus New York. 37F period SUPP period 150. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. They just can't sit on the bench and say, I have jurisdiction. It doesn't work that way. It must be on and for the official record in written form so we can lay our fucking eyes upon it, ladies and gentlemen, or it is void. Once jurisdiction is challenged, it must be proven on the record. All right? Legislative intent regarding appeal. It is clear that the legislator meant to keep the common law in force when Habeas Corpus Act was enacted. Under the common law, no appeals lies from a judgment in the habeas corpus proceedings, as prisoners has the right to be before other courts and other judges of the state to secure his release. Ex parte Bruganox applied in Henson versus Henson. Liberty. Broadly speaking, liberty is the ability to do as one pleases. In modern politics, liberty is the state of being free within society from oppressive restrictions imposed by authority on one's way of life, behavior, or political views. In philosophy, liberty involves free will as contrasted with determinism. In theology, liberty is freedom from the effects of sin, spiritual servitude, worldly ties. Sometimes liberty is differentiated from freedom by using the word freedom. Primarily, if not ex-philosophers from earliest times, have considered the question of liberty. Roman Emperor Marcus Aurelius wrote, "A polity in which there is the same law for all, polity administered with regard to equal rights and equal freedom of speech, and the idea of kingly government, which respects most of all of the freedoms of the governed." According to Thomas Hobbes, a free man is he that in those things which by his strength and wit he is able to do is not hindered to do what he hath the will to do. Liberty, freedom, exemption from extraneous control, the power of the will in its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from other persons. See Booth versus Illinois 1S4, U.S. 425, 22 SUP, period, CT, period, 425, 460, 46, L, period, ED, period, 623, Munn versus Illinois, or Munn versus Illinois, 94, U.S. 142, 24, L, period, ED, period, 77, and People versus Warden of City Prison, 157, New York, 116, 51, N, period, E, period, 1006, 43, L, period, R, period, A, period, 264, 68, AM, period, ST, period, reports, 7I. License, a permit granted by the sovereign generally for a consideration to a person, firm, or corporation to pursue some occupation or to carry on some business subject to regulations under the police powers. State Ex Rel Gullet versus Central Bank and Trust Co. 143 LA period 1053 79 SO period 857 858. Black's Law Dictionary 4th edition. License. Louisville and Nashville Arco versus Motley, 211 U.S. 149, 1908. The jurisdiction of the circuit courts is defined and limited by statute, and even if not questioned by either party, this court will, of its own motion, sua sponte is what they're saying. Sua sponte means on the court's own motion, okay? See to it that such jurisdiction is not exceeded. A suit arises under the Constitution and laws of the United States so as to give the circuit court jurisdiction on that ground. Only when plaintiff's statement of his own cause is based thereon. That jurisdiction cannot be based on an alleged anticipated defense, which may. Page 211, U.S. 150. And what they're talking about there is when you're bringing a cause of action, you're the one responsible for showing that the court has jurisdiction over the subject matter, okay? You're the one saying because it was a violation of my unalienable rights, my substantive rights, okay? This court has jurisdiction, and it's found in Title 28, 1331 or 13... 43B, all right, if you're doing federal, all right, because the federal government does protect rights. In a dictionary from like the early 14 or 1500s, it actually says the definition of the word federal is to be the protector of rights, okay? Be set up, which is invalid under some law or provision of the Constitution of the United States. The Circuit Court has no jurisdiction in the absence of diverse citizenship of a suit brought against a railroad corporation to enforce an alleged contract for an annual pass because, as stated in the bill, the refusal is based solely on the anti-pass provisions of the Hepburn Interstate Commerce Act of June 29th, 1906, C. period 3591, 34 Stat 584. The practice in such case is to reverse the judgment and remit the case to the circuit court with instructions to dismiss the suit for want of jurisdiction. Want of jurisdiction, want of prosecution, for stating a claim for which relief cannot be granted, ladies and gentlemen. In any tribunal court find absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Now, what's interesting here is you will never see, and at least I haven't come across it yet, but we have used this in the past, territorial jurisdiction. You'll never see many challenges or court references talking about and speaking to the latitude of territorial jurisdiction. Well, why does that come into play? Because the Union of States are most certainly different than the federal enclaves and territories in Washington, D.C. So it's a territorial issue at that point as well. That therefore the tax was void because in violation of the provisions of the Constitution of the United States. Page 211 U.S. 153 states, which forbids any state from passing a law impairing the obligation of contracts. Okay, that's Article 1, Section 10 in the Federal Constitution, Article 1, Section 16 in the Nebraska Constitution, and again, you can find that in all 50 states' constitutions. You just got to go look for it, okay? The cause was held to be beyond the jurisdiction of the circuit court. The court saying by Mr. Justice Gray, P. period 152 U.S. 464. Loveladies Harbor, Inc., sounds like the red light district, versus United States, 27 F. period 3D 1545, 1554. Federal Circuit Court, 1994. Might have been a red light district. The separate source of substantive law must constitute a money-mandating constitutional provision, statute, or regulation that has been violated, or an express or implied contract with the United States. Luther versus Borden, 48 U.S. 112 LED 581. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them, but the people, as the original fountain might take away that what they have delegated and entrusted to whom they please. The sovereignty is every state resides in the people. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Republican form of government or republic form of government. Magistrate, Merriam-Webster's Dictionary, an official entrusted with administration of the laws. Magistrate, Black's Law Dictionary, 4th edition, page 1103. Person closed with power as a public civil officer. State ex rel. Miller versus McLeod, 142 Florida, 251, 194, SO period 628, 630. A public officer belonging to the civil organization of the state and invested with the powers and functions which may be either judicial, legislative, or executive, but the term is commonly used in a narrower sense, designating in England a person entrusted with commissions of the peace, and in America one of the classes of inferior judicial officers such as justices of the peace and police justices. Martin versus State, 32 Arkansas 124, ex parte White, 15 Nevada 146, and 37 AM period report 466. State versus Allen, 83 Florida 655, 92 SO period 155 and 156. Merritt versus Merritt, 193 Iowa 899 and 188 N period W period 3234. The word magistrate does not necessarily imply an officer exercising any judicial function and might very well be held to embrace notaries and commissioners of deeds. Schultz versus Merchants, Inc. Co., 57 Missouri, 336. Maine versus Thibault, 448 U.S. 1, 1980. Title 42 U.S.C., subsection 1983. When we come back, we're going to be talking about 1983 lawsuits, okay? And one of the things I want to tell you is if you go look up how 1983 got started, it was to give slaves the privilege, all right, of claiming that one of their civil rights had been violated. Not unalienable rights, not substantive rights, a civil right. And a civil right, ladies and gentlemen, is a fucking privilege, all right? It is very distinct and different from an unalienable right, okay? A civil right is something that has been granted by a bunch of dipshits with pens and pencils writing on paper, conjuring up privileges that they can guise as rights. And in some instances, I agree with civil rights. But as far as the venue, it kind of disgusts me. Because civil rights implies that you're a fucking slave, because the very notion of a 1983 lawsuit was to give slaves the ability to bitch about what they believe to have civil rights, okay? So, which are privileges. We'll be back here in a little bit.